Good afternoon, everyone. This is Jamelia Morgan speaking. I use she, her pronouns. I am a Black woman with a green shirt on and a necklace that's made of string. I have white rimmed glasses and wavy hair. I am the faculty director at the Center for Racial and Disability Justice here at Northwestern Pritzker School of Law. As a disabled persons organization, the center is dedicated to advancing a more equitable society by promoting the rights and voices of marginalized people, with a particular focus on the intersections of race and disability. At the core of our agenda here at the center is the goal of preventing the confluence of racism and ableism from impacting the day-to-day lives of people, especially disabled people of color. As an academic research center housed at Northwestern Pritzker School of Law, our center is rooted in scholarly research, critical theory, and interdisciplinary collaboration. We are committed to advancing racial and disability justice through academic inquiry and public advocacy, engaging in discourses and actions aligned with our mission to explore and challenge systemic injustices. I want to welcome you all to our panel event today, Disability and Reparations, and extend thanks to our panelists, our ASL interpreters, and our incredible staff here at the center for their work in making this event possible. The United States is in a moment of retrenchment when it comes to racial justice, disability justice, truth, reconciliation, and repair. There are attacks on teaching about the history of race and racism in schools. There are attacks on any meaningful efforts for and towards diversity, equity, and inclusion. There is backlash to disability rights and the broader civil rights regime more broadly, and the literal dismantlement of agencies tasked with the enforcement of civil rights and disability rights. This panel will discuss strategies for public and legal advocacy for reparations, even in this moment of retrenchment. Despite the backlash, campaigns for reparations are still ongoing and have achieved success. Our panelists will make the case for reparations and how to think about reparations that redress the harms to groups with histories of oppression, including efforts to obtain reparations for Black American survivors of the Tulsa Race Massacre and the survivors of psychiatric institutionalization. So with that, I'd like to now introduce our panelists. Eric Miller will be introduced first. All right, so after receiving his Bachelor of Laws in 1991 from the University of Edinburgh in Scotland, Miller received his LLM from Harvard Law School. He later returned to Harvard as a Charles Hamilton Houston Fellow, going on to become a joint fellow at the Harvard Criminal Justice Institute and Harvard Civil Rights Project. Miller is a clerked rather, for Judge Myron Thompson, as well as Judge Stephen Reinhart. And prior to joining the Loyola Law School faculty, where he currently teaches, Professor Miller taught at St. Louis University School of Law. In his work, he pays particular attention to the study of policing race and problem-solving courts. His scholarship focuses on the intersection of criminal justice with sociology and criminology. Professor Prianka Nair is Assistant Professor of Clinical Law and Faculty Director of the Disability and Civil Rights Clinic at Brooklyn Law School. The clinic represents adults with intellectual and developmental disabilities with respect to a range of issues, including access to public benefits, housing, guardianship termination, and restoration of rights. Prior to joining the faculty at Brooklyn Law School, Professor Nair worked as a public interest attorney at Disability Rights New York. She conducted abuse and neglect investigations, focusing on access to services in correctional facilities across New York State. She has also litigated cases and led policy changes to achieve equal rights for people with disabilities. Her litigation includes cases involving violations of the Americans with Disabilities Act, the Individuals with Disabilities Education Act, and the 14th Amendment. She has also represented clients in all aspects of guardian and related proceedings in state and federal court. Professor Nair completed her Master of Law at Columbia University, where she was a Kent Scholar. Prior to this, she worked as a solicitor representing the Australian federal government at the Australian Government Solicitor. Thank you both for taking the time to be with us today. I will open with a broad question and invite you all to answer based on your research, the work that you're doing in community. What are reparations, and how should we think about reparations, in particular in the context of disability? If you could both start with a brief image description, that would be really helpful. All right, so Priyanka, maybe you can get us started.
Yeah, absolutely. Hi, everyone. This is Prianka speaking. I have long hair that is now no longer black anymore. It's kind of streaked with gray. I have a necklace that's meant to be representative of the colors of the Australian coastline, blue and green. Um, the colors are there. I think everything else is maybe a stretch. And I'm wearing a black shirt and a black blazer, and I'm really, really excited to be here. I I have some thoughts. There are many, many different kinds of reparations frameworks, but I think that there are some unifying themes. And so I thought it might be most helpful for me to speak to you about what some of those themes are. The first is, of course, that it is addressing reparations, look at addressing the past. So while the nature and the form of reparations may vary, um, the unifying theme amongst reparations movements is this recognition that in order for reparations to be truly effective, they have to acknowledge the past and seek to deviate from that past in very meaningful ways. So reparations movements recognize that the path through oppression to social healing really requires reckoning with that history. And without that examination, that injustice will continue to manifest in contemporary systems and policies. So understanding how injustice manifested in the past also helps determine the form that repair will take. So that is one theme of reparations. Another one is a very broad conception of what harm is. So a reparations rubric it provides the scaffolding to look beyond narrow legalistic conceptions of harm to more subversive ones that might actually completely challenge practices and policies that are often regarded as normal, and I say that in inverted commas, and may even be legally sanctioned. So, for instance, individuals in institutionalized settings, like psychiatric hospitals, for instance, might be subject to things like chemical restraints and forced mental health treatment and forced confinement, um, which may lawfully or clinically or socially be authorized by reason of their disability. And the pain expressed by these individuals with disabilities in response to their treatment may often be disbelieved or dismissed by staff and police. And there may be no real cause of action within the legal system for multiple reasons, including the fact that we don't tend to weigh very highly the testimony of people complaining of such abuse and neglect. So and the response to treatment can actually be pathologized as part of their disability. And so in that way, their experience could be rendered invisible. And reparations actually takes a step of, or a reparations framework actually recognizes those harms that might not be given legal form, it renders them visible. And then another part of this is a broader conception of remedies. If you have a broader conception of harm, you can also have a broader conception of remedies that go beyond the limits of, for instance, anti-discrimination law. We are seeing in the past few years, the most conservative Supreme Court in 90 years, and they held in a case called Cummings that emotional distress damages were just not available under Section 504, and that's kind of the Rehabilitation Act, which is one of the seminal disability discrimination acts. And some courts have held that because it's not available under Section 504, it's not available under the Americans with Disabilities Act, which bases its remedies on Section 504. So you can see that today we have to think very carefully as disability advocates about what remedies might be legally available, and if we are not going to be able to access emotional distress damages through those statutes, we sometimes any remedy that comes out of a legal process will not fully encompass the experience of the people who are seeking those remedies. Most of the harms that people experience because of discrimination, they're not necessarily physical. They are typically emotional. So all to say that courts fail to recognize the breadth of the harm that people suffer, and increasingly we're heading in a direction whether that is being narrowed. And with reparations or a reparations framework, the remedies are tailored to the needs of the people who have been harmed by that historical injustice and continue to be harmed by the lack of recognition of that historical justice. And so remedies can look like memorializing the harm, ensuring that that harm is never forgotten and is taught in schools, creating memorial sites to commemorate the people who might have experienced harm and might have died or been injured as part of that process. So there's a broader conception of remedies. So those are the three things that I will say. They address the past, there's a broader conception of harm, and because of that, there's a broader conception of the remedies that are available.
Thank you, Priyanka. I mean, where I sit currently at Northwestern Law School, we're about maybe 20 minutes north of the south side of Chicago, where for the last 10 years, the Chicago Torture Justice Memorials it's an organization that have been seeking reparations for survivors of police violence and torture under the John Burge campaign. So they have been successful in, directly to your point, getting not only compensation for the harm, but also memorials, educational materials, and the like to commemorate what happened and to preserve the historical memory. I'm also about 20 minutes south of Evanston, a city that allowed or enacted an ordinance to provide reparations for Black descendants of enslaved people. And their particular program is a kind of housing voucher program. So again, just to kind of situate myself within the ongoing spaces and movements that are doing this work. All right, Eric, what do you think in response to this question? You know, what are reparations? If you could talk a little bit about your work, that'd be great.
Hi, thanks, Jamelia. My name's Eric Miller. My pronouns are he, him. I am a white-looking, middle-aged man with a red and white checkered shirt on, graying brown hair, and hazel eyes. So I'll just start by saying for the last 20 years, I've been litigating on behalf of the survivors and descendants of the Tulsa Race Massacre of 1921, in which the Black neighborhood of Greenwood, Oklahoma, was burned to the ground by about 25,000 citizens of the rest of the town of Tulsa, white citizens. Our last two survivors, Leslie Randall and Viola Fletcher, are 110 years old, but there are tens and maybe hundreds of thousands of descendants of the massacre. And so in thinking about what is reparations, I think Priyanka's done an amazing job of explaining what reparations are. I will say that I think that reparations has a relatively narrow core that distinguishes it from other forms of relief, which is that reparations is both the process of making amends by repairing an injury inflicted by some wrongdoer or group of wrongdoers on some victim or group of victims. So it's this sort of tight three-part relationship between wrongdoer, wrong, and victim. And then it's also the process by which the victims and survivors of the injury make a demand for the sort of repair that they think they are due. And this aspect of reparations in which the victims or survivors demand, or their descendants make a demand, is important, especially thinking about the current climate, but also historically, because it's ways in which groups are who are traditionally marginalized or subordinated assert their equal standing with other members of the community, and in particular institutions and agents that seek to subordinate them. So it's a form of demand for equal recognition. So for me, reparations is a bottom-up, grassroots-led process of empowerment that demands both an accounting for the direct injury inflicted on the victims or survivors or descendants. So victims includes descendants, but also the circumstances that led to the injury by charting both the direct and indirect ways in which some people or communities had to bear the burdens of that injury and in which others have profited off it. And so this process of accounting, so people often think of it in terms of truth and reconciliation commissions and the like, but there are other models if you're comfortable with that. This process of accounting is deeply important. Why? Because in the case of the Tulsa Race Massacre, the state of Oklahoma acknowledged that for 75 years they engaged in, and this is a quote, a conspiracy of silence, end quote, to hide the massacre. It's not in history books. It still surprises people when you tell them about the massacre. And I think what we're seeing currently is an effort to expunge records and databases of information essential to helping people, but also of creating new forms of database or lists that are designed to hurt people. So when we talk about the new Department of Health and Human Services is proposing creating an autism registry. And the experience that we've had in Tulsa is that these sorts of manipulations of historical records and databases are incredibly powerful in creating narratives of inclusion and exclusion that simply erase a massacre that burned down 40 city blocks, rendered overnight 8,000 people homeless, 3,000 people disappeared from the historical record, either killed or fled. We know of at least 300 who were murdered. And so when thinking about what reparations looks like, I'm going to put in the chat a link to our Justice for Greenwood project. The sorts of reparations that we are demanding are, yes, a victims' compensation fund, so monetary reparations, but also the access, so a descendants business support program, a descendant employment preference program, descendant contracting preference program, building a level 1 trauma center hospital, and the release of hidden records, which are the sorts of things that I think apply more broadly to other forms of reparations, including reparations for people with disabilities, which are designed to create a world in which folks who have been targeted for various sorts of violence or erasure are given equal access to their community and given a level of respect and standing that makes them full citizens. So I'll stop there.
Thank you both for the helpful sort of definitional work of, what are reparations. I want to talk now about how you frame reparations, and it came through in your opening remarks. As I said in the introduction to our panel, we're in a moment of retrenchment. There are efforts to hide histories alongside with the active forms of violence that are happening across the country. It's not only just the rhetoric, but the loss of funding and programming and what that means for people with disabilities and people of color, people that are being, taken, from their families at this moment and sent over to prisons abroad. So I see these as connected, but, in this moment where there's so much going on, how are we framing reparations in the work that we're doing? What are, just to, talk about what you mentioned, Eric, sort of this notion of equal standing, equal recognition. I also am reminded of Professor Dr. Linda Steele's work and the framing around sites of conscience. Sorry. And so I'm wondering, in the work that you both are doing, how are you speaking about reparations? What frames are you using to make it something that, despite our history, um, representative groups, constituents can get behind and understand? And maybe, that same order, if that's okay, Priyanka, maybe we could start with you.
Sure. Sure. Hi, this is Prianka speaking again. So I have been trying to think about, I run the Disability and Civil Rights Clinic at Brooklyn Law School, and I see a weariness amongst my students, amongst my clients, about what law and the legal system can really achieve for them. And I think they are expressing something that disability justice advocates have been saying for a really long time, that a rights-based system will get you so far and is necessary, but is not sufficient. That indeed those remedies, those ways of seeking remedies can be very inaccessible to people who live at the intersection of race, gender, disability, and socioeconomic status. And so what I think about is, and disability justice refers to a set of 10 principles that were articulated by Sins Invalid, which is a theater group, and Patty Byrne, Mia Mingus. There's all these extraordinary people who really talked about that experience of living at the intersection of all of those identities and really not being seen at all by, or there not being a framework to really understand their experience and also the remedies that they were seeking, or the world that they hope to create. So it's a utopian vision, but also a practice, disability justice. And disability justice at its heart, I think, fundamentally questions state power and carceral systems. And I find an interesting tension between that and reparations, which is often framed, at least in international law, as the idea of holding states accountable for historical harm. So how this creates an interesting paradox that I'm looking into and that I'm thinking and exploring. So I want to frame reparations as something that disability justice movements can adopt, that they can, that may already be part of a disability justice practice, but is a necessary ingredient of holding states accountable as we are creating webs, care webs, and systems of caring for each other that turn away from the state. I still think that there is state responsibility there, and how can disability justice movements seek something from the state that is meaningful to them? And so I think there are a few ways that this could happen. The first is reframing accountability beyond punishment. So state accountability doesn't necessarily mean reinforcing state power. It could really involve dismantling harmful systems and actually redistributing resources to community-led alternatives that center the voices of people with disabilities and their experiences. I think we can position reparations as resource redistribution. I mean, when we use the word reparations, it has a political valence there that I think the disability community would appreciates and requires recognition of. So rather than just monetary compensation, emphasizing reparations as returning stolen resources, power, autonomy to communities, that very much aligns with disability justice's anti-capitalist stance, for instance. Centering collective healing. So framing accountability as creating conditions for collective healing and cultural repair, not just individual payments. And that very much connects to disabilities, justices, movements and their emphasis on interdependence and on community care. Transforming rather than simply reforming. So arguing that true reparations actually have to change systems and not just reform them. And this really honors disability justice movements' calls for fundamental restructuring rather than incremental changes that maintain existing power dynamics. And also recognizing that historical injustices must be linked to patterns of marginalization that continue to affect disabled communities. And so reparations have to address both past and present conditions. I think disability justice movements have a long view of history, and a reparations discourse really augments that. So I really try to think about how disability justice and this reparations framework can supplement each other, and then also how a reparations discourse can reposition politically what disability justice movements are doing. So, for instance, there is the idea, we kind of think that the United States is post-transition, for instance, that we have transitioned from a racist past, or at least this is a theory that the Supreme Court seems to be very fond of, that we have transitioned from a racist past to a post-racist past, which I think the lived experience of people will demonstrate that that is really not the case. And so there is this idea that all of that discrimination is in the past, and a reparations framework breaks down some of those ideas, those simplistic ideas of time and ongoing racism, sexism, ableism, and forces current reckoning with that history. And I think that is also a reparations framework can put disability justice movements within that discourse of transition. We are still very much a country in the process of transition. We tend to think of other states as being in the process of transition, not the United States, but this is very much a country that is still reckoning with that past and hasn't made any peace with it. I think that is the power of a reparations discourse here. And I think disability justice movements can really harness that. So that's some of my thinking. I'm happy to talk more, but I'm going to stop there.
Thank you, Priyanka. All right, Eric, to the question, frameworks for thinking about reparations, what you've used in your work, what you're thinking about in any advocacy efforts you're engaged in.
Great. Again, hard to go after Priyanka because she's does such a great job. But so just to build on some of the stuff that Priyanka has said, I think of reparations, there's a couple of different ways to think of reparations. And so a standard one is thinking of an injury in the past that continues on to the future, so or to the present. And so a classic version of that is thinking of reparations for slavery in the United States as focusing on a wealth gap that was created by the forced uncompensated labor of slavery that you can then trace into a sort of differing paths of wealth accumulation between white populations and black populations. And it's a valid way of thinking about reparations. It's one of the ways I think about reparations. But the way I prefer to sort of foreground reparations is thinking about reparations as concerned with present injuries structured by the past. And so we often talk about structural racism, structural ableism, structures of subordination, domination and subordination. And I think it's important not to forget that though these structures are, as it were, impersonal, they are exist through institutions and rules and habits of behavior that go on over decades and generations. These structures were created by people, they are maintained by people, and they are used by people to empower themselves. And we can know who these people are. And we can also know who the people who are harmed by these structures are. And so again, that's part of the accountability practice that I think is important as part of any reparations movement. The second thing that we discover when we look at these practices of using structures of power to empower particular populations and subordinate others is that these structures are often quite violent in ways that we don't acknowledge. They're violent for Black people, but they're also violent for people with disabilities. And of course, these groups overlap. And they're violent in ways that we often do not acknowledge. So one of the things that I learned like viscerally, so I have a Scottish accent, I'm a Scottish person, I don't come from the United States, but working with Black people in the United States through Tulsa was that every Black family has, within a generation, a story of violence to their ancestors. And I think that that's true in sometimes similar, sometimes different ways for people with disabilities whose exclusion from society can also be, can often be a form of either low or high level violence. I mean, we see high level violence in the treatment of especially people with disabilities during the pandemic. I mean, that revealed a very state a state that was not concerned with people with disabilities. So that then pushes me into a couple of radical ideas that I get from Bell Hooks, which is in the case of race-based reparations, her idea of loving Blackness. And in the disability sphere, this idea of loving disability, I think, which also comes from Audre Lorde, is really quite powerful. And so when I think of reparations, first of all, I want to recognize that reparations in the United States has tended to focus on race-based reparations. It tends to focus on reparations for discrete racial groups, so Japanese Americans, for the incarceration during World War II, descendants of enslaved people, victims of race massacres in Tulsa and Rosewood. I think the reparations framework, as Prianka said, is more capacious than that. And so in addition to working on the Tulsa race massacre, I've been developing a proposal for reparations for victims of sheriff deputy gang violence in Los Angeles County. These are law enforcement officials who have formed gangs with names like the Vikings, the Banditos, and the Regulators. And they engage in various acts of violence against communities of color in neighborhoods in Los Angeles County, including Linwood and East LA, which are predominantly Latino, and Compton and South LA, which are predominantly Black. And while the violence is often race-based, it's not targeted at one race, but many. And hidden behind the racial targeting is the fact that these sheriff deputy gangs also target people with disabilities, and in particular, people with mental disabilities. And that's nothing new if you are informed about police violence in general. These law enforcement gangs also produce disabilities, both directly to the people they attack, but also, as Priyanka suggested, indirectly with the people who suffer stress, mental illness, and other trauma through having a friend or family member killed, or if they have to support survivors, or if they are threatened with retaliation. So a lot of the reparations that we are thinking about in this case involves both responses to the disabling physical impacts of violence and the deep intergenerational trauma and psychological impacts associated with it, as well as the cost associated with caring for people who have been impacted by deputy gang violence and their terror tactics. And so one of the ways I think of reparations for victims of deputy gang violence is thinking about what it means to be a community that experiences joy. I think that joy is actually quite a radical political experience. Why? Because what would community spaces that look like in which the county of Los Angeles, who employs the deputies, provide support from the house, down the street, to the school, or to employment, or to the hospital, and then to the park, and then back home, in ways that make it safe, secure, and supported for civilians to move about and obtain the sorts of access and help they need. And I think that this applies not just to Black and brown people, but also to people with disabilities. Like, what does it look like to have spaces not just of tolerance, but in which folks are loved and experience joy? And what that looks like is building new sources of access to medical and social work support, as well as repurposing schools and rethinking about the point of schools, of libraries, and of services that increase accessibility to communities impacted by this sort of debilitating violence. So that's my reparations framework.
May I,
Absolutely,
do we have
absolutely.
time? I don't want to, I know you
Yes,
have a
please.
schedule. I love that. I love that, Eric. And I would say that part of that joy is also kind of reassigning power to people who don't typically have it, right? And so I was looking at one of the examples of reparations that I find so compelling, actually, the Fund for Community Reparations for Autistic People of Color's Independence, Survival, and Empowerment, which I'm just going to call the fund. But the fund was actually established by people, including Lee Sinjin Brown, who is an autistic person, identifies as an autistic person of color. And one thing that, and they provide grants to people who need it. You don't need to prove that you have autism. They will not inquire as to your medical history because they recognize how difficult it is to actually get a diagnosis, you know, especially if you live, again, at that intersection of race, disability, and all of the prejudices that might come with that, and the difficulty with accessing a diagnosis. So they just provide funds for food, for clothing, for anything that you might need, without asking too many intrusive questions about, do you qualify? You know, just because you exist, you get it. And if you believe you have autism, and without any of the surveillance that goes around it, but also as a way of pushing back against practices that have harmed that community in the past. So, for instance, the fund will not give grants to parents who want to engage in ABA, applied behavior analysis therapy, which for many autistic people of color is often, or autistic people generally, is often meant not being able to exhibit behaviors related to autism, having those pathologized and prevented, not being a full person. So it's a great, you know, I feel like reparations, or that reparations fund, is really about shifting who is the expert, and what they are, and who is actually the holder of the power and the expertise, which so much and really feeds into what you're talking about loving autism, loving being or identifying as a person with autism, and honoring that. So I really love that framework to look at reparations through, as love and justice and care.
So I want to invite the audience to start thinking through questions and responses to our helpful sort of panelist comments and frameworks here. So keep that in mind. I'm going to be coming to you all soon. I wanted to ask one question about legal barriers. Now, we are situated at law schools. One of the reasons why I think it's important to have disability justice principles to the law school setting, because and legal education, legal institutions, is because law is a site of violence, as it's been noted. Many of the most harmful, violent policies, I'm thinking about what I teach and what many of us teach, the notorious Buck versus Bell decision, where the Supreme Court upholds the forcible sterilization of Carrie Buck and sanctions the eugenic practices, which ultimately results in, something like 60,000 people in the United States being forcibly sterilized, probably seriously undercounted, but that's the number that I've read. But then also the way that law cuts off opportunities, pathways to the sort of transformative social change that undergirds the reparations platform, that undergirds disability and racial justice movements. I teach the In Re African American reparations case here in the Seventh Circuit. And it's such a distressing decision. It's an attempt to hold companies that profited from the forcible labor of enslaved Black people accountable today. And the Seventh Circuit throws it out. So law can be a barrier to the transformative change. And so I'm wondering, in our, next kind of few minutes before we open it up to Q&A, what are some of the legal barriers for those on the call that are working within or alongside legal institutions or using law as a tool for social change? If you could talk about those and maybe how we can work around it.
I feel like Eric is probably better.
Eric's been in the trenches on
he's
this
been in the
issue.
So so it's Eric. I will talk a little bit, talk briefly about it. So the Ninth Circuit, which is essentially all the states, all the federal, it's a federal court that covers all the states on the West Coast and then one state in from the West Coast. It's a very large circuit. Also has a case similar to In Re African American Descendants called Cato versus United States, which in the 1990s essentially said that the ability to get reparations on behalf of Black taxpayers for slavery, similar to the Seventh Circuit case, the class was too hard to define, causation was too difficult to show, and too much time had passed. And so I want to talk a little bit about the too much time has passed. So I first worked on reparations for the then 150 living survivors of the Tulsa Race Massacre in 2003, and we asserted a very straightforward claim under the 14th Amendment of the United States Constitution's Equal Protection Clause, claiming that the massacre and the destruction that went along with it violated the Equal Protection Clause's promise to protect people from race-based property destruction and violence. And that case would have been a slam dunk if it were not for what is called the statute of limitations, which is a doctrine that says that you must file a constitutional lawsuit within 3 years of the injury happening. So that would have been in 1924. Courts will suspend the statute in certain circumstances, and we gave the court good reasons to suspend it. However, the 10th Circuit, which is the circuit that Oklahoma's in, decided not to do it. More recently, in 2020, we filed another case claiming that the destruction of Greenwood was a public nuisance, which means that the city of Tulsa blighted Black people's property, and so they have a duty to repair that blight. Burning a neighborhood to the ground is certainly a blight. Even better, there's no statute of limitations on public nuisance, so you can sue for stuff that happened decades ago. However, in September of last year, the Oklahoma Supreme Court said that our public nuisance claim was really a race discrimination claim, and that's not the sort of thing for the courts, but for the legislature. All of this despite the fact that we removed any mention of race in our pleadings and referred only to property damage, and that the court in Oklahoma has given relief to other claims stretching back 80 years. So I think the real obstacle to reparations is courts' fear that granting relief is too political, even if the law is relatively clear. And so even though we asked the court in the first case to do something legal but unusual and suspend the statute of limitations, they said no. And when we asked the court in the public nuisance case to follow the law, the Oklahoma Supreme Court instead rewrote public nuisance law to deny us relief. And so that's the big challenge about relief in the courts. If the court thinks that what you're asking them to do is too long ago and requires too much justice, they'll kick you.
Thank you, Eric. Priyanka, did you want to add anything
Yeah.
to?
I mean, I suppose, you know, I think that reparations is sometimes better conceived of as a political rather than a juridical project, you know, for many of the reasons that Eric just expressed. Courts don't really do anything except consider, wait, sorry, I have to qualify that. Courts do things, but they consider each case on its own terms. So those things, those legal concepts of privity and nexus and the statute of limitations, these can all pose real barriers for people to actually access justice through the legal system, or access reparations through the legal system. And also fundamentally, a juridical system is kind of concerned with a trial of isolated cases for an individual or a specified class of common class members in a class action within the parameters of a specific legal formula. And it does sound like on occasion they will expand the boundaries of that specific formula to exclude certain types of claims that they're not comfortable with, that don't fit neatly within those parameters. And so they're not typically able to respond to violations that are massive and systemic, because they're premised on the idea that norm-breaking behavior is the exception rather than the norm, you know. And so we're approaching reparations or tend to begin from the perspective that norm breaking, it's not norm, that this is the lived reality. That's the power of reparations, right? That it centers the experience and dignifies the experience of the victims of that. And victims is usually a word that comes freighted with a lot of negative connotations of passivity and vulnerability and those ideas. But actually, in a reparations context, they're very powerful, because that lived experience is the beginning of the analysis of what the harm has been. They are actually positioned as agents of change in a reparations discourse. That's very different to how the legal system might see them or sideline their experience. So I think in many ways, the legal barriers are, the system itself is really not built for those kinds of claims, and is in fact built to exclude them. And in fact, that is what we're seeing is happening over and over again, which is very, very unfortunate. But
so I wanted to include a resource. You know, both of you mentioned sort of the political sphere as being more amenable to these sorts of reparation claims. And there are a number of bills that we've been tracking at the center that shows you the progress being made. Reparations for Indigenous communities, survivors of forcible sterilization. And so you can look at the sort of legislative activity on that particular link. We have 2 questions, if I may switch now to our Q&A portion. The first question: how do we educate the public that reparations go beyond but still include monetary compensation? That's a tricky one.
It's
yeah,
Eric. So that's why I think the accountability process is so important, because it's important to explain to people what the injuries are. And so, for example, if you just say slavery, then it sounds like one big undifferentiated thing. but it includes a whole bunch of practices such as buying and selling people, um, various forms of sexual assault, ways in which institutions profited off insurance and things like that, that can be helpful. But I think even more helpful is explaining the ways in which current practices of social exclusion rely upon our ingrained understandings developed from the past to allow for harm in the present. So if you think about, for example, mass incarceration depends upon tropes that dehumanize and exclude violence against Black people from really counting as a problem. If we think about the ways in which the immigration system is working, they depend upon and include ways in which dehumanizing the lives of people from other countries and their status within our country is, enables them to count as people of equal standing. Same thing goes for disability. And then once you start explaining the injuries, you then recognize that money alone is not enough for the remedy, especially because often giving someone a paycheck, a payout, requires them to expend all that money immediately on trying to ameliorate the harm that's happening to them, to buy a house, to get trauma relief through healthcare, and so on and so forth. And so what we really need to change is the circumstances in which people live in order to provide them with spaces in which they can thrive and feel joy and be loved. And that requires more than just money. It requires the sorts of resources I've discussed earlier.
I can, unless you want to move to the next question. So I think that there is often an argument that's made that, reparations cannot be engaged in because, how are we going to be able to afford it? That's billions of dollars in payment. It doesn't make sense. How are we going to do that? Who do we pay it to? And I think that there are some legitimate questions there, but then there are also there's also a failure to actually investigate what reparations payments could look like. So and an unwillingness on a federal level to really examine that. But I like a conception of reparations that goes beyond compensation, because for some groups, compensation itself is an insult, can be conceived of by the victims of the violence as being a way to pay for the past and kind of siphon it away as something that now we've resolved that, we've paid for it. And so there is an article that I was reading in the Washington Post about reparations to Native Americans who actually expressed the view that they don't want those reparations because their justice traditions require the actual restoration of the land relationship and not monetary payment for that. The land is not a natural resource, but it's a relative and a source of spiritual comfort and power. So reparations as compensation really isn't going to address the harm that they've experienced. And this is where the power comes from, centering victims of that violence. And I really mean victims in that powerful agents of change way. Centering what is actually going to be meaningful to them. And I feel like the John Burge example that Jamelia has spoken about is so powerful, because other than compensation, the community groups really sought so many other ways of addressing the harm, including memorialization, including compensation for sure, but also including education about that history of torture that the Black and Brown communities were subjected to. That's now part of the curriculum in schools. That was very meaningful to those communities whose stories are often not respected or told or are lost to history. And I feel like that's something that you were talking about, Eric, with people who are simply not accounted for in history. This is a real memorialization about it. And many of making reparations is not necessarily here. It's a construction project. It goes beyond the payment of money to actually building safer neighborhoods, better schools, less punitive justice system. So yes, some of these take an investment of money, but I think we are remiss if we don't think about how those systems benefit all of us. And I think there is a tendency to think of compensation as just sum of money taken from one party to be paid to another party without recognizing that we actually all benefit from making these kinds of profound repairs to our systems. So maybe that's one way of telling that story.
Thank you both. All right, we have time for one more question. It is, I would say a lengthy one, so I'm just going to read for a second. All right, so it asks that, okay, building on Jamilia's question about legal barriers, I'd love to hear panelists' comments on barriers erected not by legal institutions writ large, but by the inherent biases and risk aversion of attorneys working in the disability rights movements, protection and advocacy agencies, etc. What can be done to address these biases and build the collective power and necessary to transform these systems of violence rather than simply reform these systems via rights-based litigation? Really helpful framing there. So any thoughts about dealing with ableism within the field of advocacy and among the advocates doing work?
I can start, Eric, unless you want to go. I do think that one of the complexity of disability reparations is that so many of the systems that we think of as, or if you're a disability advocate or someone who has a disability and you're a self-advocate or you're experiencing those systems, is the fact that so many of them are sanctioned by law, that they are now part of policy to address problems like homelessness. There is now a greater push that has been there since, certainly Eric Adams' time as mayor in New York, of moving unhoused people from subway systems into psychiatric hospitals and essentially civilly committing them. And so one of the problems is that there is a profound, and there's this fundamental ableist idea that treatment is beneficial. Treatment conceived of in this very punitive carceral way is beneficial for people who don't know what is good for them. And that has been a hard idea to shake. And a hard idea to kind of challenge on a legislative level. And so I think there are some things that advocates need to be doing to really move away from that kind of ableism. I think we need to abandon myths about independence, that this is just one case and it's siloed and it's about this particular issue. We really need to be thinking about community organizing around reparations by focusing on collective healing rather than individual compensation. And that sometimes is not something that, public interest organizations or legal organizations can really do, because we're trying to work within certain parameters that have been created for us. The others are also building that cross-movement solidarity. So, the disability rights movement and the racial justice movement have deep historical connections. And so we've got to leverage those intersectional histories to strengthen the alliance between those movements is something else that I think about, and something that I think could be part of the practice of protection and advocacy systems, for instance. And I don't know if they're already doing this, by the way. I'm just speaking off the top of my head as someone who used to work as a staff attorney there and did not deliberately do these things. And that's just me. And I think also there is this idea of, seeking to redistributive justice without actually waiting for government action or for state-sanctioned action. I think those models build power from the ground up. And an example of that is the fund that I talked about earlier, that investing in those kinds of systems. And also, I think public interest disability organizations should also be thinking about multiple getting remedies through multiple channels simultaneously. So, you know, you've got local, state, and federal government actions, private sector accountability, community-led initiatives. I think we should be approaching this spherically. And so create multiple paths to success rather than just relying on a single approach. And some of this means rethinking about how we engage in legal advocacy. But I think that is the challenge for our next generation of disability attorneys. And so that is something that, you know, we're trying to do in the clinic. And it's not easy and we get it wrong a lot of the time. But I do feel like it's more exciting because we engage a lot more with the community. And I think the victories are more meaningful because of that.
If I can just say one quick
absolutely.
one. So I do want to, just thinking more broadly about this question, not just in terms of ableism, but in terms of imaginationalism. I think a lot of attorneys are unwilling to do imaginative work because they have to get paid. And so the sort of work that reparations requires requires you to be willing to lose. And I think clinics and law schools are especially important in allowing this sort of work to happen. I'm at a law school because I don't have to worry about not getting paid. I do all my reparations work pro bono, which means that I am in a privileged position and able to take chances that maybe other lawyers are not. And so it's important, I think, to support institutions that can take chances and engage in developing novel ideas. And the reason why recognizing that you may lose, I think, nonetheless, it's important to engage in the litigation. So just to sort of a little bit expand on what something Prianka was saying earlier, is even though the courts may be unreceptive, the thing that I found in the Tulsa litigation was the fact that we were able to go to court empowered the community in a way that then, especially second time round, helped generate community organizations to engage in building. So filling the courtroom with people supporting the Tulsa survivors case helped develop the grassroots movement that then helped elect the first Black mayor of Tulsa, Oklahoma, who we are now trying to pressure through Project Greenwood to pay reparations to the last two survivors and do our other demands. So it's imaginative work in two ways. One is you have to use your legal imagination, but the other is you have to use your social imagination. Lawyers aren't always good at being activists. I'm not. I've had to be prodded into it. But I think that the activism part turns out to be the most important part of it, because what you build after the court cases go away is a lasting, interconnected community that are empowered to fight for justice. And I think that that is the most important part of certainly the reparations legal work that we can do.
I think that's a powerful and important note to end our conversation on. I want to thank you both for taking the time to be with us to talk about your work and for the incredible advocacy that you do. To our audience, thank you for the time, and know that this is not our last conversation. We are in the process of thinking through our next event. And I think that last question might be a pretty good one to have a conversation about ableism within the legal profession and among legal advocates, for example. So thank you all for spending the hour with us. Thank you to our ASL interpreters. Thank you to the CRDJ staff, Jordan and Dimitri, for your help in pulling this together. It's been wonderful to be here with you all.
Thank you so much. This is wonderful.